Good afternoon, everybody, and welcome to this edition of the Bonavero Discussion Group. We're really excited to have the topic today, which really combines two particular research interests of the Bonavero. So one is whether companies have human rights, or interest in the intersection between business and human rights is sharply raised by the conversation we'll have today. And the second is our interest in the regional human rights systems. So Patricia Viata, who is sometime in the near future going to be a research visitor at the Bonavero Institute of Human Rights, will be our presenter. She's currently an associate professor in basic and fundamental human rights at the University of Erlangen-Nuremberg. And we also have with us one of our former early career fellows, Dr. Nick Friedman, who's currently a lecturer in public law at St. John's College in Cambridge. Both of them have written on this topic, and I think we're in for a really interesting conversation. So those of you who haven't joined us before, the format here is that the presenter, in this case Patricia, will speak for 25 minutes to half an hour, followed by Nick, who will speak for 10 to 15 minutes, and then we will entertain questions and comments from the floor. The Q&A button is at the foot of your screen on the right-hand side, so please feel free to add anything there that you'd like to ask. And at that stage, I'm going to hand over to Patricia. Welcome, Patricia. Great to have you here.
Thank you very much. Thank you for the invitation, for giving me the chance to talk about the question whether companies have human rights. Do companies have human rights? Well, if we refer to a natural law tradition of human rights deriving pre-state inalienable rights from human qualities such as dignity, freedom, and equality, the answer is obvious: no. A company understood as a for-profit organization with limited liability and legal personality is an artificial person who does not live and breathe. Only natural persons do, and consequently only the weak and vulnerable human being deserves human rights protection. This restriction applies even if we assume, in line with current corporate theory, that companies not only serve the financial interests of their shareholders, but various objectives, such as those of the company's employees, creditors, suppliers, and customers. From this philosophical starting point, the natural law tradition, we can deduce the need for human rights protection of companies, if at all, by means of a derivative rights approach. This approach assumes that companies can and may only rely on human rights to the extent that natural persons behind them are entitled to human rights protection. In its famous advisory opinion from February 2016, the Inter-American Court of Human Rights adopted such an approach. The court stated that in principle, legal entities such as companies do not enjoy the rights established under the American Convention and do not have direct access to the inter-American system under a victim status. However, the court conceded that natural persons must be afforded the same protection under the Convention, even if they are exercising their rights via a legal entity. An individual who is seeking to assert rights connected to the activities of legal entities, such as property rights, may access the inter-American system directly. The systematic incoherence of this approach is indicated by the court itself, when it states that there is no single formula to determine whether a natural person is exercising his or her rights by means of a legal entity, and whether one can assume the necessary direct relationship between the natural person seeking protection and the legal person suffering the breach. In this regard, it is left unclear if international human rights protection means ignoring or respecting the decision-making system of domestic company law. The inconsistency of this approach is most evident when the Inter-American Court acknowledges that for the purpose of admissibility of an individual complaint, legal entities may fulfill the requirement of exhaustion of domestic remedies if the domestic proceedings relate to the allegations made before the Inter-American system. In the following, I will argue in favor of acknowledging corporate human rights. By this, I mean rights addressing the legal person company as the relevant right holder and serving as an imperative, inalienable yardstick for state intervention. In line with this, the European Court of Human Rights assumes that companies enjoy a large number of rights under the European Convention, such as procedural rights, the prohibition of discrimination, but also respect for home and freedom of expression for mere commercial purposes. In search for a normative justification of corporate human rights, the jurisprudence of regional economic courts will give us guidance. They draw our attention to the fact that alternatively to human dignity, two different concepts may serve as a normative basis for recognizing corporate human rights. That is economic liberalism on the one hand and the rule of law on the other. While economic liberalism cannot free itself from its status as a political concept, the rule of law principle is legal in nature and universal in content. I will argue that both principles have emancipated themselves from their European origins and are of trans-regional validity. To the spread of economic liberalism. The end of the bipolar world order had various vitalizing effects on the power of private economic actors to participate in the progress of international economic law. One effect, declared as the most important development of international law at the turn of the millennium, was that the number of newly established or revived permanent international courts had increased significantly. A main feature of many of the courts established after 1989 is that they were set up in the framework of regional integration projects and classical liberal state interests, above all, the liberalization of trade and economic relations. Against this background, most of the so-called new style international courts continue a tradition that was established by the European Court of Justice in the 1950s. From the very beginning of the European integration project, the founders of the ECJ had opened its doors for natural persons and for private companies. After the end of the Cold War, this approach to empower private business entities, as experienced in Europe, spread all over the world. The failure of the communist alternative to the Western model of a liberal and democratic order oriented towards capitalism and the triumph of the market economy paradigm explain the willingness of some states to become involved in regional economic integration agreements. Agreements in which a permanent court open for private litigants monitors compliance with treaty obligations. I have focused my case law analysis on courts that publish their decisions in English or French. On the African continent, I have assessed the role of private business entities in the East African community, in the Southern African Development Community, and in the Economic Community of West African states. On the European continent, I've analyzed the status in the European Union and in the European Economic Area. On the American continent, I've examined the empowerment of the private sector in the Caribbean community. As we know, this trend of empowering private economic stakeholders by means of individual substantive rights and state-independent rights of action is still exceptional in international economic law. The vast majority of bilateral and multilateral trade agreements notified to the WTO only empower states. On the human rights jurisprudence of regional economic courts. If states consent to empower private business entities in their economic integration system, both substantively and procedurally, this has a consequence. The legal order, even if primarily designed as an interstate system of economic law, will be influenced and determined by human rights. A common feature of the regional economic courts I looked at is that they have expanded their judicial control to include human rights review at the initiative of private litigants. The early European Court of Justice, the EFTA Court, the East African Court of Justice, the SADC Tribunal, and in part the Caribbean Court of Justice stand for this commonality. The ECOWAS Court is an exception because of its institutional character as a human rights court since its reform of the legal protection system in 2005. The courts would apply human rights standards of protection, adopt the two-step approach that, firstly, the contracting states have generally authorized them to uphold the law of the respective treaty regimes, from which, secondly, it follows that they are also competent to use human rights, an expression of general principles of law, as standard of review. The violation of human rights consequently constitutes a violation of the respective community law regime. This approach was first adopted by the European Court of Justice, which, in application of the treaty establishing the European Coal and Steel Community and of the treaty establishing the European Economic Community, has since the 1960s derived a system of human rights under community law. The court did so by recourse to the common constitutional traditions of the member states and their international treaties for the protection of human rights. Supranational power and state measures implementing EU law must be assessed on this basis. In the Lisbon Treaty, the EU member states confirmed the continuing relevance of the human rights standards derived as general principles of law, despite the codification of a written catalogue of fundamental rights in the Charter of Fundamental Rights in the meantime. The EACJ also invokes its general jurisdiction to monitor the interpretation and application of the EAC Treaty in order to review state measures against human rights standards. By contrast to the ECJ, which was confronted with the silence of the founding treaties in this regard, the EACJ can rely on general objectives of the EAC integration project as enshrined in the EAC Treaty. In this treaty, the member states committed themselves, among other things, to respect the Banjul Charter. The EACJ interprets these not as mere political commitments, but as binding legal obligations. In a very similar way, the SADC tribunal relied on the general rule of jurisdiction, which entitled it to supervise the interpretation and application of the SADC treaty. According to the tribunal, the treaty includes in the binding program of obligations of the member states the objective to act in accordance with human rights, democracy, and the rule of law. As a consequence, the tribunal affirmed its jurisdiction to rule on all disputes, including those against states on issues of human rights protection. The SADC tribunal is, interestingly, the only economic court that has experienced fundamental political backlash because of its human rights jurisprudence. After several judgments ruling against the Zimbabwean government, the tribunal was de facto suspended. The Caribbean Court of Justice has not yet taken the step to enforce human rights guarantees from foreign international treaties as a violation of community law. Nevertheless, it also makes clear that general international law, which the general rules of jurisdiction and the CCJ agreement enable it to interpret, inseparably includes human rights protection. Also, the EFTA court joins the group of courts that, originally designed as economic courts, have evolved into human rights protection courts. First, by pointing out that EEA law should be interpreted in the light of the European Convention on Human Rights and judgments of the European Court of Human Rights. In a later step, the EFTA court also classified the protection of human rights as a general principle of EEA law, to be respected within the scope of application of EEA law. Now on normative individualism. If we systematize the human rights case law resulting from these lines of jurisprudence, we gain two central insights. First, the catalogue of human rights enforced by regional economic courts is by no means limited to guarantees that are typical for economic interests, such as property rights, procedural safeguards, or the prohibition of discrimination. Especially in the systems of African economic integration, they extend to existential human rights guarantees, such as the prohibition of torture or the right to life, effectuated by means of public interest litigation. But also the ECJ derived a catalogue of unwritten human rights of community law which address the individual as a private person, such as respect for family life, the inviolability of the home, or freedom of religion. These lines of cases suggest that economic liberalism can only be successful if the human being can live his or her life freely and without fear, and if the natural law tradition of human rights is respected in the supranational and domestic legal order. In the following, I'd like to focus on the second insight we gained from the human rights jurisprudence of regional economic courts. In this jurisprudence, in a primarily economic context, we can discern the legal theoretical concept of normative individualism that builds on the subject quality of private stakeholders, thereby encompassing both the human being as well as companies. The normative equalization of human beings and companies as an underlying assumption is evident in the famous Van Gent and Loos decision from the 1960s, when the ECJ included a private company under the category of the individual by stating that, and I quote, "The community constitutes a new legal order of international law, the subjects of which comprise not only member states, but also their nationals. Community law therefore not only imposes obligations on individuals, but it's also intended to confer upon them rights, which become part of their legal heritage. Individual here includes a company." A consequence we can recognize in all integration systems assessed is that companies play a key role in legitimatizing supranational and state sovereignty. This premise applies not only in the highly centralized EU, but also in legal communities where the member states were reluctant to transfer sovereignty in an EU-like sense to supranational community organs. For example, also the EFTA Court argued that due to the central role of individuals and economic operators, the EEA agreement created a new legal order that must be distinguished from classical international law. In line with this, the ECOWAS Court of Justice held that the ECOWAS community legal order also has a distinctive feature that must be distinguished from classical state-centered international law. From human rights to fundamental rights. The almost logical consequence of this normative equalization of human beings and companies is that the ECJ, in its early corporate human rights jurisprudence, did not question or discuss the ability of the legal entity company to be a bearer of human rights at all. However, we can identify a linguistic turn in the respective case law. In its opinion on the leading case of Internationale Handelsgesellschaft, Advocate General Dutillier de la Motte had referred to, I quote, "the possibility of community law ensuring by itself and in all circumstances the protection of human rights recognized as fundamental." The ECJ, by contrast, ruled in this case that respect for fundamental rights forms an integral part of the general principles of law protected by the Court of Justice. The linguistic turn from human to fundamental rights practiced by the ECJ without much ado indicates much more than an etymological inaccuracy. It embodies a rule of law commitment towards human beings and companies as subjects of legitimacy. The fact that human rights protection can and must include fundamental rights protection of companies, that the one does not exclude but necessarily complements the other, was impressively demonstrated by the ECOWAS Court of Justice in a ruling from 2019. In various proceedings, the ECCJ had to deal with a clearly different wording of Article 10C and Article 10D of its 2005 protocol. In the English language version, ECOWAS law distinguishes between rights of action of individuals or corporate bodies on the one hand and individuals on the other. Individuals or corporate bodies have the right to have determined that the action or inaction of a community official has violated their rights. According to the wording of Article 10D, by contrast, only individuals can apply for relief for a violation of their human rights committed by an ECOWAS member state. The English notion individual had to be contrasted with the French wording, which extends the right of action to toute personne victime. In the case of Dexter Oil Limited, a company incorporated under the laws of the Republic of Liberia against the Republic of Liberia, the applicant had complained about the unjustifiable detention of its property by the respondent state. In deciding on whether a company could lodge a human rights-based complaint against the state, the court, in a first step, applied a systematic method of interpretation. by referring to the clearly narrow English wording of Article 10c, it assumed that the drafters of the law had intentionally rejected a right of action for legal persons in human rights proceedings. In a second step, however, the ECCJ restricts this conclusion by taking internationally accepted conditions into account. Thereby, the court points to the existence of fundamental rights, which are to be distinguished from human rights in that they also address legal persons as rights holders. In addition to the right to a fair trial, which it had already classified as fundamental in a previous case, the ECCJ also included the protection of property and freedom of expression among the rights that also apply to legal persons. In the words of the court, human rights imply the rights that belong to all human beings, irrespective of their nationality, race, caste, creed, and gender, amongst others, like the right to life, the right to health, and the right against torture, inhuman and degrading treatment. On the other hand, rights of a corporate body are rights that are fundamental and necessary for the existence of a corporate body which a legal entity can enjoy and be deprived of. The inference drawn by the court is far-reaching, notwithstanding the contrary wording of Article 10d, which restricts the right of action in both the English and French version to the violation of human rights. The ECCJ concludes that the existence of substantive fundamental rights necessarily results in the right to procedural enforcement. The right to property is consequently one of the exceptions that grants a corporate legal entity the right to bring a claim under Article 10d. The jurisprudence of regional economic courts enables us to derive and generalize a rule of law-based justification of corporate human rights. The postulate that state or supranational power may not be exercised arbitrarily applies not only to human beings, but also to companies, since arbitrary state action can have onerous effects on companies that, in the words of the ECCJ, threatens their existence. Only the primacy of human and fundamental rights over domestic legal arrangements can ensure that the rule of law is realized as a central principle in any legal system. In the context of courts of regional economic integration systems, this needs no further justification. After all, companies are the central economic parties, and a system that strives for legal protection of economic integration would lead itself astray if we were to exclude companies from the scope of protection of the rule of law. However, it does not follow that there's an irreconcilable divergence between human rights and fundamental rights. Rather, the rule of law justification is of general nature. The idea of defense, which is inherent in this justification, connects natural law-based thinking of human rights and the fundamental rights of companies. If we look back in the history of political ideas, the universalist natural law language primarily served to morally justify the fight against political oppression. In this regard, Article 2 of the French Declaration of Human Rights of 1789 expresses the interconnectedness between the human rights to liberty, property, and security, and the resistance to oppression. If we recognize this defense function against state arbitrariness as the common normative justification, there's no qualitative difference between the human rights protection of natural and legal persons, beyond human rights, which are linked to the human body as such as human dignity and physical freedoms. As a consequence, addressing the fundamental rights of companies under the heading of corporate human rights is coherent. They share the same moral justification and are interconnected in substance, since civil and political rights belonging to the third generation of human rights already entail protection of certain aspects of economic life. Now, can we transfer this rule of law approach towards corporate human rights as developed in regional economic systems to the regional human rights systems, namely the Inter-American and the African? As said, the approach is already adopted in the jurisprudence of the European Court of Human Rights. In doing so, the European Court of Human Rights can rely on the openness of the Convention's text and on the Convention's historical background. As can be derived from the Travaux Préparatoires, the drafters had understood the European Convention from the very beginning as a commitment to the liberal state of the West against new dangers in the shape of a rapidly expanding communist East. Against this background, the Convention's full name, European Convention for the Protection of Human Rights and Fundamental Freedoms, signals that the protection system was and is supposed to be open for companies' legitimate use of the Convention rights and freedoms. The inter-American and the African human rights systems are grounded in fundamental different legal, cultural backgrounds and doctrinal details. The African Banjul Charter on Human and People's Rights is firmly grounded in an African philosophy of law and human rights and was developed as an instrument against colonization and alien domination. One of such guiding philosophies, which is said to be common to much of Africa, is the prominence of the group or community in the lives of individuals. The Pact of San Jose, by contrast, reflects the natural law thinking of the Enlightenment, when the preamble refers to the essential rights of man, and when Article 1, Para 2 relates the state party's obligation to respect rights the state party's obligation to respect rights to the protection of persons, defined as every human being. Although every human rights interpretation has to bear these particular underlying values in mind, I would argue that we need coherence in dealing with corporate human rights, not only to counteract the fragmentation of trans-regional human rights protection, but rather for a legal theoretical reason. Protecting corporate human rights, now understood as a corpus of fundamental rights necessary for a corporate body to exist and to actively participate in a domestic or supranational legal order without arbitrary interference, does not call into question the natural law tradition of human rights founded in human dignity or the African philosophy on group rights, but complements it. As demonstrated, the ideal of economic liberalism, encountered in the principle of the rule of law and centered about private business entities, has spread around the world. Thereby, this ideal creates an additional underlying value that already informs the African as well as the inter-American human rights system. Thank you very much. That was my part.
Great, thanks, Patricia. Full of information there. And in fact, one of the questions already has asked whether you can provide us with a list of the cases. So maybe that's something that we can talk about and make available to people who registered and participated. Right, turning to Nick.
Thanks very much, Kate, for including me today. And thank you very much indeed to Patricia for sharing this very stimulating work with us. Which I find quite challenging for some of my own views on giving human rights to corporations. I'm going to structure my responses today around what I see as the two key aspects of Patricia's argument. The first is methodological, concerning this magisterial survey that Patricia has done of the jurisprudence in this area, which she uses to derive some principles to justify human rights for corporations. And then the second is the principles that she derives from this analysis, namely economic liberalism and the rule of law, which might, as an alternative to human dignity, provide a normative foundation for giving human rights to corporations. For my part, I'm very nervous about giving human rights to corporations. And I hope that my engagement with Patricia on these two themes will make clear what some of my worries are, even as I want to continue thinking about the compelling arguments that she raises. So let me turn then to the first theme, the methodological theme, which is about the relationship between the foundations of human rights and the jurisprudence of human rights. And I want to begin here by making a critical distinction between human rights in their legal sense and human rights in their moral sense. Human rights are first and foremost moral rights. They're moral rights of special importance and universality. And we have these rights independently of the law. That's precisely why the law should recognize and protect them. Now, of course, in many regimes, human rights are turned into enforceable legal rights, into what we might think of as constitutional rights. But the legal concept is always answerable to the moral concept. We rely on that moral sense of human rights to give content to the legal sense or to criticize the legal sense. And who should have rights as a legal matter and what the content of those human rights should be depends on who should have them as a moral matter. And I make this distinction for two reasons. First, the problem with some of the jurisprudence on corporate rights is that the moral concept becomes answerable to the legal concept. Because the corporation can hold legal rights, we readily reason that it can also hold human rights. And indeed, in Patricia's book, she demonstrates precisely this connection between, on the one hand, courts recognizing a corporation's standing to assert legal claims in that court, and on the other hand, courts then recognizing their standing to assert human rights claims. And to my mind, at least, that's a shift from the legal to the moral, and it's a shift, I think, in the wrong direction. Second, Patricia makes an extremely significant finding in her survey, which is that economic courts tend to give human rights to corporations, while human rights courts are more skeptical. And it makes sense, I think, that regional economic courts, whose primary task is to limit barriers to trade, that these courts are the ones empowering corporations to defeat governmental limits on their behavior. And to be clear, I want to make sure I don't mischaracterize Patricia's argument. She's just using this case law as inspiration for her own moral investigations. But I do wonder whether the use and selection of these cases, and in particular the focus on economic courts, might give us a somewhat biased perspective on the possible foundations of human rights. So let me turn then to Patricia's second theme, which is about economic liberalism and the rule of law as possible foundations for human rights. And here I want to ask two questions. First, whether liberalism and the rule of law really are alternatives to human dignity. And second, I want to ask how human rights adjudication might need to change to reflect this quite different normative foundation. So beginning with the first question, when we talk about dignity as the foundation of human rights, we're really talking about autonomy or moral agency. Autonomy is the idea that we are authors of our own lives, that we can act in accordance with right and wrong, the idea that we're capable of planning for the future. That capacity is what gives us dignity in the Kantian sense. And the list of human rights we have and the content of those rights is derived from this understanding of what makes human life valuable, of what basic things are necessary for human life to go well in modern political communities. So the very interesting question that Patricia poses in her paper is whether economic liberalism and the rule of law can play this role for corporate human rights. And my initial sense is that liberalism and the rule of law cannot provide an alternative foundation to autonomy, since any attractive view of those concepts would itself be grounded in autonomy. Liberalism and the rule of law are, of course, not goods in and of themselves. They're good only to the extent that they protect still more fundamental values. Whatever normative force liberalism and the rule of law might have derives from those deeper values. And in both cases, to my mind, that deeper value is autonomy. With respect to liberalism, for example, the ideal of autonomy is at the core of a tradition stretching from Kant to people like John Rawls and Martha Nussbaum. For the rule of law, too, in the work of Lon Fuller and Joseph Raz, the value of the rule of law is that it respects the citizen's autonomy It respects the citizens' capacity to make plans and structure their lives in accordance with legal norms. Now, since corporations are not autonomous moral agents, since they don't have dignity in this sense, it seems to me that liberalism and the rule of law cannot lend their normative force to corporate human rights. Now, of course, this is not the only way to think about liberalism and the rule of law. For example, we might adopt a more libertarian or neoliberal understanding of those concepts, sort of along the lines of Friedrich Hayek or Robert Nozick, in which the central values are the protection of property and a kind of negative liberty. Liberty is the absence of constraint. Now, this is obviously not the place to adjudicate these competing political theories. The more fundamental point I want to make is that we have to root liberalism and the rule of law in some more ultimate value. And whether we then think that these provide an attractive basis for giving human rights to corporations will depend very much on what that ultimate value is. So let me turn then to the second question under this theme of economic liberalism and the rule of law, which is about how human rights adjudication might need to change if we accepted these principles as an alternative foundation for human rights. So let's think, for example, about the list of human rights and the content of those rights. Our current list of human rights to life and privacy and religious belief and equal treatment and healthcare and so on are based, as I said, on a theory of what makes human life valuable, of what human life is like in modern political communities. And if we replace that theory with something very different for corporations, with something like economic liberalism or the rule of law, we would then have to come up with a very different list of rights with very different content. It cannot be that such a radical change in the foundation of human rights would coincidentally lead to the very same list of human rights. And we can readily see this if we try to apply our existing list of human rights to corporations. How can a corporation be tortured? What is the corporation's sphere of intimacy that should be kept private? What is the corporation's spirituality? What are the grounds on which corporations have been oppressed historically, like race or gender or religion, on which we might now base their right to equal treatment? Some of these rights can't be applied to corporations at all, and the rest apply only by the loosest metaphor, which suggests to me at least that they ought not to apply to corporations at all. So what rights might then follow for a corporation from a foundation of economic liberalism and the rule of law? Well, one worry is that these principles might not lead to any particular set of rights, but simply to a kind of general principle against regulating corporate activity, which is in fact how corporations have wielded their human rights in the United States. And as I've said, I think it makes a lot of sense that we see in this incredible survey Patricia has done that economic courts are playing a critical role in awarding human rights to corporations. But the issues go far beyond content. Think about the doctrine of proportionality, the idea that there are strict limits on the extent to which the state can instrumentalize me for goals that I haven't chosen for myself. That idea is grounded in autonomy. And if we strip away that grounding, would this thinking apply to human rights for corporations? Should limitations on those rights be narrowly construed? Should these rights be entrenched? In many constitutions, human rights are entrenched to protect minorities from a tyranny of the majority. And to that extent, human rights influence and counterbalance the democratic process. But in many places, corporations sufficiently influence and counterbalance the democratic process themselves in a way that makes it unnecessary and possibly quite harmful to give them entrenched human rights. Should these rights be adjudicated by judges? Again, judges are independent and unelected, and hence they're well suited to protecting groups of people that might be abused in the democratic process. But at least with respect to corporations, I think I would be inclined to side strongly with Jeremy Waldron and say that the legislature should be deciding the existence and content of those rights, not the courts. So the fundamental point here is that if we bifurcate the foundation of human rights so that it's one thing for corporations and one thing for people, then my sense is that we might have to bifurcate our entire mode of human rights adjudication. So by way of conclusion, I just want to make three final remarks about the problem of human rights for corporations. First, the corporation itself is merely an instrument. And so unlike in the case of human beings, any argument for the corporation having rights of any kind, including human rights, must be an entirely instrumental argument. And I have to say that I find the instrumental argument against human rights for corporations to be very powerful. These rights are almost exclusively used by corporations to defeat attempts to regulate their behavior in the public interest. They're used in ways to prevent the real human rights of real people from being realized. So one thinks of the impact of Citizens United, the way in which protecting a corporation's so-called right to free speech has dramatically interfered with the voting rights of flesh and blood Americans. Or one thinks of Hobby Lobby, the way in which protecting a corporation's so-called right to religious belief has dramatically interfered with the reproductive rights and freedoms of working American women. So this is in part why I'm nervous about corporations being human rights holders in general, and about corporations holding human rights specifically. Second, I certainly think it may well make sense for corporations to have some legal rights, some procedural rights, with a certain content akin to the content of some human rights. But I wonder whether those need to be labeled and treated specifically as human rights, along with the special normative baggage that comes with that designation. My sense is that any such rights should be awarded and repealed by legislatures following a simple majority vote. Finally, it is true that important features of human life, including our privacy and expression and so on, extend to our work life. And so it seems to me that the best argument for giving human rights to corporations is a derivative one, that this serves to protect the human dignity of the people who work and transact with it, from which the content of human rights is derived. But if that's true, then I think the solution to corporate human rights is one of standing. And the seeds of this solution can be found in Patricia's book. In her book, Patricia makes a compelling argument that widening the rules of standing to allow corporations to bring legal claims enhances access to justice and promotes the rule of law. And so along the same lines, one might then argue that a better solution to the problem of corporate human rights is to give corporations associational standing to assert the real human rights of their real human stakeholders. That concludes my remarks. Thank you.
Thanks, Nick. Well, that's a really strong engagement. Patricia, I don't know if you'd like to respond to that now, or if you'd like to hear some questions and have an opportunity to respond later. What would you prefer?
Well, I would prefer to reply directly, maybe to some aspects.
Could I add, while you're going to do that, I think it would be great if you did. There's one thing I just wanted to add, and it really relates to Nick's last point, first of his last 3 points, which is the instrumental aspect of this. If at the end of the day, the corporate structure is a legal fiction, which we entirely create for particular instrumental purposes, it really seems to emphasize some of the points that Nick has made about this. Actually, any decisions we make about what rights we attach to corporations actually flows logically from this legal fiction we create. There is not some a priori extra legal roots for corporations. They are fundamentally rooted in the legal system, which is very different to human beings. And therefore, thinking about how we should think about the corporate rights of, or the rights of corporate institutions, seems to me to be largely a legal problem, which is created by the legal system actually, and it isn't rooted in some extra legal moral status of corporations.
Yeah, that's definitely true, because it depends on the definition on the domestic level. Here we see interconnectedness between the national law on companies and the protection on the international level. That's true. I'd like to get back to this functional approach a bit later. First, I'd like to refer to what Nick said about the shift from the legal to the moral concept. Can we derive a principle out of an analysis of case law? I would say yes, we can. If this case law represents a normative principle, a more generalizable principle, we can. It does not exclude the legal character or the character of a principle. Here, what I found out when looking at the case law is that the normative concept we can derive or we can gain from the analysis of the case law is a prohibition of arbitrary sovereign power as a general principle. And this principle applies not only when we look at the human being, but when we look at every relevant stakeholder in a society. And in this case, as Kate said, the decision on who is the relevant stakeholder for society depends on the definition of the national law on companies. That's true. We don't have a human being which is defined. On the other hand, this rule of law-based approach and this normative foundation in a prohibition of arbitrary sovereign power allows us to look at companies in their responsibility to protect human rights. Because we can see some companies exercising power which is similar to state-like power. If we look, for example, at a company like Facebook, which defines law regulating what type of opinion is acceptable, creating a legal system, exercising sovereign power more or less. We can apply this approach also to human rights companies as being responsible for human rights protection. So I think that this is the idea that subjects which or who are relevant for society must be protected from arbitrary sovereign power of a supranational or of a national state body or of a private body which exercises state similar sovereign power. That's a generalizable principle. And it's a normative one. It's not just a, how to say, just the one aspect of case law, which is without moral significance. I think this is significant. That's one reply to Nick. The second one on the alternative economic liberalism and rule of law creates as a justification beyond human dignity. I still do not understand how this alternative justification in the rule of law questions the human dignity justification of fundamental or human rights. I don't see the conflict. We can see a conflict if, as you said, we have the fear that corporations misuse human rights to defeat regulation in the public interest. And here I want to make one very, very fundamental point. This conflict between individual needs, financial needs, for example, on the one hand, and public interest on the other, that's common to every human rights issue. It applies in the same way to natural persons misusing human rights for their financial interest against public interest laws done by the legislator. To give you an example, when I personally oppose night curfews imposed to contain the corona pandemic, I also use my human right to freedom of movement to defeat regulation in the interest of public health. So this conflict is inherent in every human rights conflict, and it always poses us to balance private financial interests with public interests. That has nothing to do with the doctrinal foundation or justification of corporate human rights. It's an inherent issue in every human rights conflict. Any interference with human rights must serve some kind of public interest in order to just be justifiable. So that's not a particular problem of corporate human rights. That's one thing I wanted to add. And then to get back to an aspect you and Kate mentioned about moral agency. I am convinced if one follows an individualistic approach in a Kantian sense, it's clear that only natural persons can be considered as moral agents. On the other hand, we can take a functional or, as Kate said, instrumental approach, and we can ask what socially important and relevant functions even a purely profit-oriented corporation performs. That's another kind of understanding of moral agency, because here we can see there's economic innovation created by private economic stakeholders, creation of jobs, even the possibility for shareholders to invest in their retirement arrangements. So if these functions are also taken as a basis, there's no reason why companies should not be granted a certain moral right to exist. And the really relevant question is not the question of human or fundamental rights holders, but that is the question on what kind of human rights the company can refer to, and how is the balancing between mere commercial financial interests and public interest is practiced at the end of the day. I think this is the relevant question. The question is not the one of whether or not they can be holders of human or fundamental rights, because I don't see why the acknowledging these kinds of justifications for corporate human rights calls into question or questions the human dignity justification of human rights. It's at the end of the day, it's a matter of balancing public health or public interest in general and financial commercial interests. And it's clear that they have to be subordinated if public health interests are more important for society. That's my reply to Nick and a little bit to you, Kate.
Great, thanks, Patricia. Really, really good conversation. So I'm now going to turn to some of the questions that have come in, and just to remind those of you who are listening, please do add any questions that you might have for Patricia and or Nick. So the first question I'm going to put is, where it concerns freedom of expression, for example, we have a situation where oppression often comes from big companies rather than from states. So, for example, Facebook and Twitter, who may take views on taking down posts in relation to freedom of speech, for example. How can this be reconciled with granting those companies human rights on their own, i.e. rights that are not associated with users, is the question, or potentially even shareholders, if one wants to extend it to that. But so what do you think about that, this idea that actually large companies are often now asserting, as you yourself acknowledge, the kind of a so-called sovereign power to limit rights? How does that fit? Is it not better to think about them in the same way we think about the state, which is another large, powerful corporate institution in a way?
I think we have to think into this direction, because the more a private company exercises sovereign power or power in a state-like sense, the less the one can rely on the protection of human rights itself, because it gets nearer and closer to state-like functions and to state-like life, so to say. So I would indeed say that if a company such as Facebook is exercising state-like functions and, for example, creates the own currency, lays down laws regulating what type of opinion is acceptable, and acts like a state that reduces, or we have to think of whether that reduces the ability of such a company to refer on the human rights protection as a human rights holder in a state-like sense then. And it's kind of a willing decision, it's a clear decision. The more you act like a state, the less you can, as a human rights holder, refer on the protection of human rights. That's one consequence I would think of, yeah.
Sounds like a difficult line drawing exercise, however. Nick, any thoughts you'd like to make on that?
Just quickly, yeah, I mean, I think that one of the reasons why I think the corporation is so interesting as a focus of study is that in the law, I think we have a really conflicting conception of what it is. If I think about criminal law, for example, much of the writing in that area, which tries to use the criminal law to hold corporations accountable, is dedicated to the argument that corporations are exactly like people. Their minds work exactly the same as ours. They can have mens rea and so on. And then if we skip over to some of the more public law thinking, we analogize the corporation to the state. We say the corporation is exactly like the state, it wields power in the same way, and therefore ought to have the same obligations. And to my mind, at least, it seems both of those things can't be true. The corporation can't be exactly like individuals and also exactly like the state. And I think we don't really have a hope of regulating it properly unless we actually start with this more fundamental, in some ways quite abstract question of what actually is it like? And therefore, what are the best ways for the law to address it?
What I would like to add is that we have to distinguish between a kind of economic power and superiority of a company. That, in my opinion, would not lead to the fact that this company is bound by human rights law, but I would refer to kind of a structural superiority, for example, by regulating a certain space like social media, by defining what is right or wrong, what kind of freedom of expression is acceptable, what not, what is not acceptable. That's more structural superiority of a private company, not the mere economic power of a company. That would not, in my opinion, lead to a company to be responsible for human rights protection. The structural superiority would do so, in my opinion. That's one maybe line of differentiation.
I mean, it does seem that, you know, you're moving towards it's not simply because you're a corporate structure that you have human rights. There seems to, in fact, be a different principle that would underpin whether you do have human rights or not, which would vary across different types of corporation and different structures of corporation. And that itself is a, you know, complicated and interesting idea. There's another question that relates to this, which is that regarding the state-like nature of corporate power and the need to have protections against the exercise of such power, does it not dilute and preclude the human rights framework from being able to hold companies accountable to their excesses in the exercise of the sovereign power, when we recognize that companies, a center of power like the state, against whom rights are required, is also a rights holder akin to individuals and minorities? How can they both be? So it's very similar to the point that you both made. How can they both be a center of power and a rights holder at once? And I mean, don't know if you want to add anything to what you've already said in that regard in response to this question.
Well, I think that the question of human rights accountability of private companies is a very crucial one, but it's a question of procedural enforcement and the right forum, so to say. Where can we hold them accountable? And unfortunately, we cannot hold private companies accountable with a complaint in Strasbourg right now. But in some African systems, that's also changing. Like the African Court of Human Rights was at least deliberating and thinking of whether private companies might be accountable in proceedings before the African human rights system. So there's kind of a political change maybe going on to think of an international forum to hold private companies accountable. But as Nick said, and as you said, I think that that makes the whole matter much more complicated than thinking in a classical way of the state to be the one protecting and fostering human rights, and the private sector is the one which profits. But then we only think of the human being as the one who should profit. That's a very easy thinking, and it does not work anymore in human rights doctrine. We have to think in collective goods such as environment. We have to think in group rights like the African system does. We have to think of private companies to be responsible like the state is responsible. At the same time, they are entitled by human rights protection. I think the way Nick described it is a very classical understanding in a very clear-cut world, which does not exist anymore. We cannot, distinguish between the state and the individual, between the one responsible and the one entitled by human rights. The human rights world is much more complex, and we have to think in new doctrinal dimensions, thinking of collective goods, even in a system like the European human rights system. The European Court of Human Rights is confronted with proceedings relating to the protection of environmental goods, but it's a classical individual rights court. It does not really. It was not, created as a court like the African court dealing with collective rights issues. At the same time, the court in Strasbourg is confronted with proceedings dealing with collective goods, such as environment. So I think human rights doctrine has to move and has to open the door towards less classical understanding. And I try to do so today to provide a normative justification. I think this is really exemplified by the complexity that we have to think of companies as human rights holders and as entitled by human rights in the same time. That makes it complex.
Can I just add one quick thing there, just to wholeheartedly agree with Patricia on this point, that one thing that's interesting about the corporation is that it challenges our classic political theory, which divides political communities into, two units, the individual and the state. And our current thinking is about analogizing the corporation to one or the other, but actually the corporation is kind of a hybrid of those two things. One thing that's different about the corporation and the state, as Patricia is emphasizing, is that we think of the state as having no interests of its own, only acting in the public interest. But of course, it is and must be true that the corporation has some legitimate self-interest. And we need the corporation to do all kinds of important things in society that are different from the role that is played by the state. And so I certainly think there's much important work to be done in terms of building out new political theories that are perhaps more plural than the sort of tradition that we've inherited.
So just to follow on that, and there are a couple of other questions I want to come into in a moment, but I think one of the difficulties with the classic theory is it tends to have, one explanation for human rights. In fact, quite often when we look at the kind of principles that underlie why we have human rights, they're actually quite plural. Mm-hmm. So there may be a moral kind of Kantian understanding of what it means, but there may also be an institutional understanding or an argument from democracy. And sometimes if we start recognizing, taking each individual right and thinking about, well, what are the moral and legal underpinnings of this right? If it is purely a moral Kantian explanation, I'm generally unpersuaded that that fits the company. But the idea that it is an institutional fairness, which is quite close to your rule of law argument, like, for example, the right to a fair trial, it seems to me that that may say that institutions like companies should entitle them to that. So you actually need to do this work at individual right level rather than working with just one account of the underpinnings for human rights.
That's what I try to make clear, that adding more moral ideas or types of normative justification does not call into question the moral justification of human rights, but we can add and think of more and then broaden the possible scope of human rights holder by doing so.
Yeah, but you could say, for example, that freedom of religion is something that corporations don't have, because the major underpinning of that is actually a Kantian understanding of moral agency. But right to a fair trial, and the really tricky one is going to be right to property, might have different sorts of conceptions. I don't want to get sidetracked from our really interesting questions that have come in, so let me just put them to you. So the next question relates to the fact that the new regional economic tribunals, I think the question means like the ones from Africa, ECOWAS and SADC that you've talked about, are more human rights oriented. And the questioner wonders whether they're role models for Asia, which doesn't have any human rights regional court, but where potentially you might see these kind of considerations emerging in economic tribunals were they to exist. I'm going to put a couple so that you can then both respond to them. Then the next one is whether there's any moral obligation for companies working in Myanmar, and particularly in the context at the moment of the military junta, to stop making business and back democratic elected government. So what is the obligation of business in circumstances where they're working in a state where democracy is either under threat or has been overthrown? And then the questioner also asks whether the ASEAN Treaty, the Southeast Asia Democratic Developmental Organization, would have that treaty would have any relevance there. So, I mean, would both of you like to comment on that? And then we do have one or two, oh dear, their questions are leaping up here. So do you want to comment on those? Because those came in early and I think that questioner deserves some answers.
Yeah, as I said at the beginning, Nick, if you agree, I answered to the first question, and maybe if you want to, you can answer to the second one. On the first question, whether we can see a role model in these tribunal and courts for Asian integration or human rights protection systems, I'm afraid that no. as I said at the very beginning, the number of multi and bilateral trade agreements allowing private litigant to access a permanent court is limited. It's really more or less the ones I mentioned here, and there's the Spanish, the Andean Tribunal and the Central American Integration System, but unfortunately I cannot read Spanish, so I did not mention these courts here. But that's it. These are the systems allowing private litigant access to a permanent regional tribunal or court. And so there is a state reluctance in allowing access to justice for litigants. That's the first thing we have to realize. And the second one is that the way these courts interpreted their mandate and their jurisdiction is a very broad way. Like the human rights jurisprudence I mentioned was judge-made. The member states did not allow these courts to rule on human rights issues in the first place, but the courts themselves developed this human rights jurisprudence in this economic context. So I'm afraid that whatever state analyzes this kind of jurisprudence in details will be that's a nightmare for deciding on allowing private litigants to access an international court, because you see that the moment states lose their political filter or give up their political filter on economic disputes, in that moment we have tendencies like we see here that the economic courts, due to proceedings initiated by private litigants, rule on human rights issues without a clear mandate by the member states. So probably it would be a great role model for Asia, but I'm afraid that that we have to bear in mind that there's a state reluctance to integrate substantive and procedural rights in economic integration regimes or in free trade agreements. Probably that will not happen. It happened here after the end of the Cold War, because we had this tendency towards judicialization, and we had in some regional integration systems, the member states had the awareness that they needed more law, so to say, and less politics to deeper economic integration. But that leads to jurisprudence in these regional courts, which cannot be influenced by states anymore. So I think that there's probably a political reluctance to create more permanent courts and to allow more private litigants to access these courts. That was a long answer. I hope the answer was nevertheless clear.
Thanks, Patricia. And Nick, are you going to turn to the Myanmar question?
Yeah, just very quickly. I know that there are also other questions. For me, I prefer not to think about the moral obligations of companies. I think that's a distraction. I think it's more helpful to think about the moral obligations of the people who exercise power in those corporations, especially the executive and the managers. I think in principle, those people do have moral obligations to the communities and the states that they're working in. If they are doing something that is contributing to human rights violations on the ground, or if by taking some action they're not currently taking, they could bring an end to those human rights abuses, then I think morally they ought to do that. However, of course, they might be subject to a number of competing moral obligations. So on the one hand, if pulling out of Myanmar helps in some way to promote democracy, well, that's an argument in one way. But what will happen to their employees in Myanmar? What will happen to health and education services that they might be providing to their employees in certain communities and so on? So the sort of overall moral complexity that some of these corporations are in is quite tricky and needs to be thought through fully.
Great, thanks, Nick. So just going to pick up a couple of the remaining questions, probably not going to get to all of them, given we've only got 5 minutes left. But one is to point out that your argument, in a sense, Patricia, is arguing for conferring rights on companies when the way in which companies structure themselves through their corporate structures, whether it's subsidiaries or even the use of contractors, allows them very often to commit human rights abuses and to go unaccountable for that. And whether whether it makes sense. So this is really an argument saying, given if we don't have a moral compulsion to protect companies, but we have some sort of instrumental reason, is this an appropriate way to go, given the powers companies already have and the ability that they have to avoid accountability for their actions? Then there's another question that goes to Nick's point about this hybrid character of companies, sometimes looking like the state, sometimes looking like individuals. And the questioner puts an interesting point, which is that we sometimes see that with publics, that sometimes public bodies are subject to judicial review when they're carrying out public functions, and sometimes they're not, because what they're doing is more analogous to private functions. And in fact, you see it also in circumstances where we see some private companies carrying out public functions in circumstances of privatization or outsourcing of public functions to private bodies, and then they're held to the scrutiny of public law, whereas they wouldn't be in relation to other ones. So whether these mechanisms where we recognize that one institution can sometimes be performing a public function and sometimes not, might give us an idea of how to think about companies generally in the context of human rights. And then the last question I'm going to get to is one about the environment from Stefan Theil, which is, he says that he's not convinced that the environment could be protected through a collective understanding of human rights. He examined the case law of most international and regional systems in depth for his book, which is forthcoming, I can say, all of which use a classic understanding of rights holders. And he wonders whether, Patricia, you have any examples where you think that a collective understanding of rights holders might have resulted in a different outcome. He particularly says that the core issue in environmental law seems to be deference to the state by courts and leniency on private actors that pollute the environment. And neither of those would be solved by recognizing the collective recognizing that corporate institutions could bear human rights. So in some ways, quite similar to the first question I put to you around the ways in which the implications, the kind of instrumental implications of giving human rights to companies. So perhaps you both might fill up on those, and then we'll come to an end in precisely 2 minutes.
Okay, so a quick answer to the first question. The fact that corporations violate human rights of private persons in a true way, very drastic answer. If we think of someone who killed another person, the one is still, as a human being, entitled to hold human rights. If you kill someone for a religious purpose, you cannot rely on the freedom of religion, of course, but you're still entitled to a fair trial principle. That's a very drastic example. That means that, of course, the question of what human rights can you rely on in court proceedings against state measures is limited, depending on what you refer to regarding your own behavior. So I would say yes, even a company abusing and violating human rights is still, from a rule of law standpoint, entitled to hold human rights. I think the second one referred to you, Nick, or maybe I just quickly answered to the question on the environment. I don't remember the name of the case, but I know that the European Court of Human Rights had to interpret collective rights more or less in the framework of the individual rights. And so environmental matters are understood as question on the human right to privacy. And so the challenge is, the doctrinal challenge is to integrate collective good problems into the classical understanding of individual rights. And I think the European Court, but I don't remember the name of the case, refers to the right to privacy, or the respect, Article 8, so respect to home. There the doctrinal challenge is that with the individual rights concept, but we have to deal with collective rights issues. That's what I wanted to point out, that the human rights world is not that clear cut, but we have challenges we have to integrate in the classical human rights thinking.
Thanks, Patricia. Nick, last word.
Yeah, just very quickly on this point about public bodies acting privately and private bodies acting publicly. I mean, these are enormously challenging cases trying to figure out what types of principles we should apply. But in a way, I don't think that they challenge the public-private divide. What they show is that there's a gray area between these two poles of public and private, where it's unclear when one is merging into the other, in the same way that there's a point in the day where day is merging into night, and we could disagree about whether it's night or day, but those things are still quite different. Public and private would still be very different from one another, notwithstanding there's a gray area in between those two things. I think what does disrupt that binary is Twitter and Facebook. These are not companies that are running social media is not a public function by any stretch of the mind. But what these companies are doing has profound public effects, public consequences. And so thinking about how to regulate what they do raises, I think, a more foundational challenge in classic political theory. That seems to me to really disrupt this binary that we have between public and private.
Great. Well, sincere thanks to Patricia and Nick. I often find the best discussions is when there are disagreement. It really makes one think, and I think that's been a great disagreement, very, very clearly and very well expressed, and of course it's a lot of agreement too. So thank you to you both for a really fascinating conversation. Thanks to everybody who's been here for all your really interesting questions. I'm sorry we didn't get to quite all of them, but really enriched the conversation. And then just to remind everybody that next week's discussion group will be on a not unrelated topic, which is the question of automated decision-making and its impact in a time of COVID-19. The speakers there will be Eliška Pirkova and Matthias Vermeulen, and it'll be chaired by my colleague, our British Academy Global Professor, Martin Scheinen. So please look out for that. And then there are a range of further events, in particular a series of book launches towards the end of term, which you might find interesting. So look out for that. Meanwhile, thank you once again to Patricia and Nick, and to all of you for joining us today, and hope to see you again soon. Meanwhile, keep well and safe. Bye now.
Thank you very much. Bye.
Thank you. Bye-bye.